Professor Isai Berlin's two concept of liberty devised by him as positive liberty and negative liberty. So when there is complete absence of restraints, then such liberty would be considered as negative liberty. So there would be no political, social constraint on such freedom of the individual in enjoying either his civil liberty or political liberty or economic liberty in that sense without having no restriction from any side, either from the society or from the government, and such concept of liberty is considered as negative concept of liberty. But where we would found certain restriction imposed by the society or by the government, then such concept of liberty would be considered as positive concept of liberty. So, according to Isai Berlin, the positive liberty is most common and prevalent in modern democracies in the world, as we would see about the fundamental freedoms provided under Article 19, Clause 1 of the Indian Constitution, where reasonable restriction could be imposed by the state on the civil liberties of the individual citizens of India regarding on freedom of speech and expression and freedom to assemble and freedom to organize meetings and organizing political and other associations and freedom to movement and also to freedom to settle anywhere in India. So also regarding freedom of practicing any trade, commerce or any profession. So this kind of reasonable restrictions imposed by the state would be considered as positive concept of liberty. And now we'll examine the very relationship between liberty, sovereignty, and law. So, in his introduction to politics, that last express the sovereignty of the state express itself in law, as the state is a sovereign organization. Its law are binding on all. This universality of law poses a very difficult problem. Should the authority of the state be all embarrassing? Should every aspect of an individual life be guided and controlled by the law of the state? There cannot be any ready-made answer to these questions, as this involves significant considerations regarding the relationship between law and liberty. Is the law an aid to or an enemy of individual liberty? So the relationship between the law and liberty can be properly studied in the context of particular forms of government. Under a dictatorship, laws are the dictates of the dictator. In the absence of plurality of opinions and multiplicity of political parties, law can never be the reflex of social opinions. The natural consequence of Such a system is the total subordination of the individual to the authority of the state. Hence, in a dictatorial form of government, laws have a general tendency to be antithetical to individual liberty. The next question is law a condition of liberty in a democratic form of government? In a democracy, reconciliation is said to be made between law and liberty by placing authority or sovereignty and freedom in the same hands as the people who obey the law also make it through their elected representatives. A unity is established between the law-making authority and the law-abiding individuals. Generally speaking, therefore, the more democratic a state is, that is to say, the more opportunity there is for the great body of citizens to exercise an effective influence on the decisions of government, the less likely is an antithesis between law and liberty. So, Professor Hadal in his introduction to politics, points out the history of trade union law in England, of freedom of contract in America, or the agrarian legislation in Prussia are all instances of the way in which a dominant economic class uses the state to make ultimate of those legal imperatives which best protect its interests. Thus, the very critics, the two devices of the government, as according to John Stuart Mills, who was awake to the possibility when he sought to devise a criterion for discriminating between intervention which safeguards and that which stifles individual personality. So, according to Mill, liberty would allow the state to intervene in the area of other regarding actions and disallow intervention in the sphere of self-regarding actions of the individual. So, Mill divide two different kinds of actions, as one is, according to Mill, is the other regarding actions and the self-regarding actions of the individual. So, Mill also has been criticized on the tight compartment still ground that individual behavior cannot be divided into such watertight compartments. Still, his suggestion contains a significant truth. The state should leave the individual alone, where his activities is the spontaneous or inwardly determined expression of personality. And as Professor McIver, in his work The Modern State, expresses that state is best suited to perform certain specific tasks, and of its laws is the building and sustaining of that universal framework of social order within which the life of man, liberated from the encroachments and the confusions of unregulated desires, may more freely and more fully seek out the ways of its fulfillment. Hence, the very character of law limits its area of operation. When laws are made in total disregard of personality, their purpose is defeated and they become positively inimical to liberty. So, it must, however, be remembered that liberty has got to be limited. Social living entails some responsibilities, interdependence of individual lives necessarily demands certain reasonable restraints on individual behavior. So, as Professor Ben and Peters in their social principles and democratic state express that it is the paradox of freedom that we must set a constraint to catch a constraint. Again, this claim, however, many objections have been raised against this view of Professor Ben and Peters in their work Social Principles and the Democratic State. And as also we found the remarks of Professor Karl Popper in his Volume 2 Open Society and its Enemies, as he objects to determine exactly the degree of freedom that can be left to the citizens without endangering that freedom whose protection is the task of the state, but that something like an approximate determination of that degree is possible is proved by experience, as for example, by the existence of democratic states. In fact, this process of approximate determination is one of the main tasks of legislation in democracies. So, as we found regarding the very safeguards of liberty, we would like to discuss certain views including Montesquieu's complete work on spirit of laws, where he explained about separation of power. So liberty is the priceless possession of man. The bravest among the brave sacrificed their lives for the conquest of the continent of freedom. So, in that context, we could discuss the very poem of Lord Byron, the English poet, who, in his poem The Prisoner of Ceylon, completely expressed as how liberty is the priceless possession of man, and how the bravest men among the brave sacrificed their lives for the conquest of the continent of freedom, liberty which has been considerably won through countless battles and struggles, is said to be adequately safeguarded today in every democratic state. So, in this context, we could like to discuss how a bold and impartial judiciary acts as the sentinel of liberty. The judiciary in every democratic state is endowed with the proud privileges of safeguarding the rights and liberties of the citizens. Political influence on the judiciary stifles the honest performance of this sacred task. So as Professor Lasky observes, for only where power is distributed widely is there any effective restraint upon those who wield the power. Decentralization may be functional or territorial. Functional decentralization involves delegation of specific functions and powers. So also we would discuss about as the French political philosopher Montesquieu in his monumental work The Spirit of Laws, he laid the foundation of separation of power. So, as Montesquieu observed, to prevent the abuse of power, it is necessary by a proper disposition of things that power should be a check to power. So, separation of powers coupled with the principle of checks and balances is in the opinion of Montesquieu an invaluable device for preventing the rise of governmental despotism and for protecting liberty. So also rule of law, as Professor MacIver in his modern state expressed that is an important safeguard of liberty, and according to him it enables us to interpret government as an organ of society and agent empowered to work in appointed way, owing a derived authority and a delegated might, no longer the master of the state. So also, widespread social justice provides a significant pillar to the mansion of freedom. Freedom of the people is reduced to a shadow without substance if economic and social privileges become the monopoly of a select microscopic minority. Modern welfare state are undertaking varied measures for reducing disparities in income and wealth. Diffusion of economic power over widest area is a necessary adjunct to the enjoyment of liberty. So also a well-knit party system is indispensable for the preservation of liberty. The organized political party in a permanent state of tension, mutually restraining one another, ensure the continuous popular enjoyment of liberty. So, to conclude, we could examine at the very sayings of Professor Lasky and Thomas Jefferson. So, Professor Lasky put it, it is the proud spirit of citizens that is their most real safeguard. And as Professor Lasky explains that the ever-present temptation of the ruling class to glorify and abuse power is a historical fact. Against this political disease, the real remedy is a permanent mood of popular revolt. And as the American pioneer of freedom was Thomas Jefferson, the founding father of American Constitution and American Bill of Rights, in his immortal words, he expressed that in this connection, what country can preserve its liberties if its rulers are not warned from time to time that these people preserve the spirit of resistance. So we have completed the very important and vital political and legal concept, that is liberty. So in our upcoming lecture we would like to discuss another vital political and legal concept, and that is equality.